Vidya. Welcome you all on behalf of Legal Vidya to this webinar on contract drafting essentials for beginners. Let us understand about Legal Vidya. Legal Vidya was founded in 2021 with the aim of creating a platform for individuals interested in the field of law. The organization provides a comprehensive portal where people can enhance their knowledge and grow their expertise in the field of law. Legal Vidya offers various opportunities such as internship programs, a platform to publish your articles and research papers, and host interactive webinars and sessions for its members. About the webinar. This webinar is on contract drafting designed to equip participants with essential skills to create precise and effective legal agreements. Join us for an insightful session led by a seasoned legal expert who will dive into the intricacies of contract drafting, including best practices, common pitfalls to avoid any key elements to ensure clarity and enforceability. Let's introduce our founder, Sakshi Sharma. Has been awarded a young entrepreneur by RNV Global University, Bikaner. She is the compiler of the book The Truth of Life and possesses in-depth editorial skills and academic knowledge. She is the chief executive of Legal Vidya, where she has edited many books and news articles. Over to you, ma'am.
Thank you so much, Paras. Good evening, everyone. I'm Sakhi Sharma, and it gives me immense pleasure to introduce you all to our speaker for the day. It is Prashant Sir. Prashant Sir is the Principal Associate at Dua Associates, and is also an advocate on record at the Supreme Court of India. And he specializes in commercial and civil litigation, insolvency laws, and ADR, including arbitration. Sir appears regularly before the Supreme Court, High Courts, and NCLT, appellate district courts, and other forums. Prashant Sir also advises clients on various subjects, and he has over 13 years of experience as a legal professional. And in these 13 years, he has dealt with commercial disputes and arbitration matters, both domestic and international, and also insolvency laws. He has handled cases arising from transactions relating to oil and gas infrastructure, project and construction, power, energy, telecom and IT, banking and finance, and joint ventures and general commercial matters. Sir, it gives us immense pleasure that you have joined us today to host the session and you have come and given us your valuable time. Thank you so much for joining the session, sir. You can kindly begin the session.
Good afternoon, everyone. Am I audible, Sakshi?
Yes, sir.
Okay. First of all, very much thank you, Legal Vidya, for inviting me for this session. Thank you, Paras and Sakshi, for this kind gesture. Let me start by saying that when I got this topic to speak upon, contract drafting essential for beginners. So this is a very generic topic, right? If you speak a lawyer, if you tell a lawyer to speak on this topic, he can go on and on and on because this topic is a generic topic wherein one can cover a lot of aspects as to what are the ingredients of a good contract, how to draft. So let me start by saying this. I mean, of course, I have also prepared a PPT, which I will display in some time. But before going to the PPT, let me start by saying that every contract just is a story. Every contract will give you a different scenario, right? So, contract is nothing but the final outcome which two or three parties arrive at after having a discussion, after agreeing to certain terms. Now, in an era where we are today, wherein artificial intelligence has gained a lot of traction, and it is going to be the next big thing in say next 10 years, 15 years. How does the role of a lawyer, or what is the role of a lawyer or a legal practitioner in terms of contract drafting will become very important. Why I am saying this is because, see, in artificial intelligence, what happens is to whatever knowledge what we have as of now, you will insert relevant keywords and it will come out with a draft of a legal contract. So that is how the contracts will be in future, right? Wherein the scope for improvement will be very less, very less. So in that context, let me start by saying this, that drafting of a contract or any agreement, see, drafting of a contract entails a lot of things. What is a contract? Contract can be even a click wrap agreement, an agreement which you enter online on day-to-day basis. Like say, for example, if you are going to any internet portal, if you are agreeing to the terms and conditions of a legal website, then also you are entering into a contract, right? So that is also one of the contracts. Plus, there are various other contracts which we encounter on day-to-day basis, right? So the contract can be varied. There can be various forms of contract, but what is the crux, or what is the basis, or what is the basic thing for someone who is drafting a contract? So those basic things, if it is clear, then anyone can draft a good contract. And contract drafting, or any drafting for that matter, is an art which you learn on day-to-day basis. The more you do it, the better you will become in terms of drafting. Same goes with with legal drafting, with legal pleadings. Like say, for example, what we draft for courts, the aspect of any pleading before any court, right? There are certain key ingredients which you have to include in a draft, and eventually you learn, like a beginner, like why I am saying this, why I understand that a lot of you who are attending this webinar today are students, right? You must have done some contract drafting, or maybe some moot court competitions wherein you would be required to draft, or you have drafted something in terms of moot court propositions, moot court memorials and all, right? So that is also a form of drafting, not a contract as such. So let me start by saying that whenever a contract is being drafted, be it a lease deed, be it a MOU, be it a settlement agreement, be it a family settlement, there can be various categories, various forms of a agreement, contract. So there are certain key aspects which one should keep in mind before drafting. First and foremost thing is the interest of the parties, the subject matter. What is the subject matter? Like say, for example, I'll give you an example. Let's start by seeing that if someone has to enter into a MOU, which is called Memorandum of Understanding. So, what is the purpose behind entering into that MOU? So, that purpose is very important. That clarity of thought before the entering into of that agreement is very important. So, what is the subject matter of a contract becomes the most ingredient, most important part of any contract drafting. Then, when you draft a contract, you can also have a chapter or a portion which will define the definition, that what are the terms. So first you need to analyze, or first you need to see what are the terms which needs to be defined in a contract, so that it's clear for someone who is reading the contract for the first time. For him or her, it becomes very good that there is a portion which defines the terms which has been used in the contract, right? Then there is something called recital. Recital is, as I said, it's the beginning, that what is the purpose of this agreement, why this agreement is being entered into. So the recital is a prelude to the main contract which you will be entering into. The next component is also very important, which is the consideration. So what is the consideration for the agreement? I will touch upon the aspects under the Indian contract also, which talks about, or which deals with the aspect of legal consideration, what consideration is valid, what consideration is not valid. I will touch upon that also. But just to tell you, consideration also becomes a very important aspect. Then, what are the rights and duties of the parties? So, suppose there are four parties in a contract. What are the rights and duties, rights and obligations of all the parties? Laying down each and every point, covering all the points in a contract in simple language will result into a good contract. Then, what will happen if the contract fails, if the relationship becomes difficult between the parties and the parties want to get out of the contract? So that is also one of the aspect, which is essentially, and which will also there is also an aspect of compensation clause, damages clause. So these are the clauses which are very important as far as the contract is concerned. Then you have, as I said, termination clause, cancellation clause. Now, two more important clauses, or there are various other clauses, but I'm just telling you that dispute resolution clause in a contract, in any contract, like say, for example, what will happen if a dispute happens between the parties? Who will initiate the process? Are you intending to go for arbitration, or are you intending to have it a generic clause, and the parties will later on see as to what remedy they want to adopt in the future? Then you have the aspect of jurisdiction. Jurisdiction becomes very important, like other clauses. So jurisdiction will basically say, like say for example, there are two parties, party one and party B, party two. Party one is based in Mumbai, party two is based in New Delhi, right? So which court will have jurisdiction in case there is a dispute between the parties, right? So the law for jurisdiction is that you cannot confer jurisdiction to a court which does not have jurisdiction. So, like say for example, in this matter, as I in my previous example, party one is in Mumbai, party two is in Delhi. So a court in Calcutta will not have jurisdiction, right? So either the court in Mumbai or either the court in Delhi, either of these courts will have a jurisdiction as far as the jurisdiction clause is concerned. So jurisdiction clause also becomes an important aspect. Similarly, there are other clauses also, depending upon what type of contract and what is the form of contract, nature of contract. You can have various different clauses. Now, if you ask any person who deals with contract drafting, so they will use a terminology called boilerplate clauses. So boilerplate clauses are something which are standard clauses, which is used in a contract. Like say, for example, a contract of a lease deed. So there will be certain standard clauses or standard components which will be included in the lease deed. Like say, for example, if you talk about lease, so what is the most important clause in a lease? What is the rent? What is the lease deed? What is the lease amount? What is the duration of the lease? Right? What is the nature of the description of the parties? So these are the clauses which will become part of the standard clauses in a contract. Then, of course, depending upon the discussions which two parties have, the lessor and the lessee, then you can have other clauses also which you can include, right? Plus the duration of the lease. As I said, duration of the lease becomes important because the moment it is a year, a lease more than 11 months, it has to be registered, right? So these are the standard clauses in terms of the lease deed. Now, this standard clauses depends from a contract to contract. Like say for example, in a similar case, like if someone is entering into a family settlement. Now, how have or what is the relationship between the parties? Could be between the family members, right? How has the property devolved? Like suppose there is a case wherein the family members are trying to divide the property amongst themselves in a mutual amicable manner. So how has the property devolved upon the legal heirs? So that chain of title, that description becomes very important. Also, what will happen if suppose tomorrow there is disagreement between the family members themselves in terms of how the property has devolved. So what will happen, right? So as a lawyer, as a beginner, we need to understand that every contract there will be ifs and buts. There will be certain portion which are so there will be two components. One component will be a standard clause, like these description of parties, recital, jurisdiction. These will be the standard clauses. But apart from that, whatever the parties agree will be part of the flexible. So the one is fixed component, the other one is the flexible component. So flexible component totally depends on the negotiation between the parties, right? Now we are talking about simple contracts, lease contracts, family settlements, MOUs. But there are larger contracts which requires a lot of deliberations. So I can tell you in my experience, like say for example, there is a very big property, very big in the sense 2,000, 4,000, 5,000 square feet property, right? So when that lease is being negotiated, so there are various round of discussion between the lessor and the lessee's council and the parties themselves. After so much negotiation discussion, wherein both the parties tries to see that their interest is protected, So they will try and negotiate all the points. There will be discussions on various issues, various clauses. There will be various round of exchanges between the parties in terms of exchange of the final draft or the pre-final draft between the parties, and then the parties arrive at a final lease deed. So the nature of the document will be a lease deed only, but you see how much time and effort is spent on arriving at that final conclusion or that final lease deed, right? So the point which I'm trying to make here is this, that any contract, as I said, is a story, but to arrive at the final story or arrive at a final conclusion, there are a lot of things which one has to deal with, which one has to negotiate. And the idea is that all the parties are equally benefited. So it's a final document is a win-win situation for both the parties. So that is the final outcomes. That is the ultimate aim of any contract. But of course, there are various instances wherein one doesn't have much option. So this is the standard document which is offered to you. You read it, but there will be very less scope for modification. Like say, for example, a builder-buyer agreement, a simple flat agreement, right? When one goes and buys a flat, right, you get a builder-buyer agreement or a lease deed or something of that nature. So that's a standard document which is prepared, wherein you will the only option with the other party is to accept it, right? So those are also one of the instances wherein you will have to be happy or be content with whatever you're getting, right? But when one has to really draft a contract, of course, there are a lot of people here who are law students and who will eventually become lawyers and will start exploring the arena of contract drafting, right? So there can be various instances, there can be various permutation combinations, right? So everything has to be considered, and then a final result has to be drawn. A final agreement has to be drawn. Now, this is in terms of the standard options or standard clauses in a contract. What is important here is that use as simple as as simple word as possible. There is no need to complicate the draft. If someone is of the view that we will use flowery English, we will use difficult words to make a contract difficult to look nice, that is not the way. You pick up any good book on drafting, the first thing the book will say that be as clear as possible in terms of drafting, so that tomorrow if someone reads a contract, even a layman can understand it. So that is the test for a good draft. Secondly, use simple words. And as I said, drafting is a continuous learning process. The more you do it, the better you will become eventually. It's like court pleading, right? Any court pleading you pick up, like even if I pick up my own draft 10 years back and the draft which I do now, there will be a sea change, right? Because now if I draft something, I have that 10 years, 12 years of experience with me, that what went wrong, right? Like say for example, I'll give you a small
हेलो
example.
जो
If
मैं पढ़ा रही
you are
हूँ वो
drafting
नोट्स बना
any pleading,
ओके
right, there are various things which becomes very important, like the jurisdiction clause, the cause of action paragraph, right, the paragraph with regard to how has the parties, what is the main dispute, what is the crux of the disputes, right? So as a lawyer,
हेलो
I cannot go wrong in that.
जो भी मैम पढ़ा रही है उसके नोट्स बना
Otherwise, the others there
हाँ
is
पढ़ रहा
other
हूँ
there will be other party who will file application for rejection of my plaint
कल परसों बनाओ
under Order 7, Rule 11 of the Code of Civil Procedure, right? So eventually you learn. So the point which I'm trying to make here is this, that drafting is a continuous process
ठीक है
and you learn eventually. So if suppose if you are given to draft something, a basic moot court memorial, and you think the draft is not good, think over it. Why you think the draft is not good, right? Same is the case with contract drafting. You think there is something lacking here, then you think about it. What is lacking? What could be done better, right? If suppose you have already filed something, you have already prepared something, you can, after maybe couple of days, couple of weeks, you can again look back to the document and see if something can be improved further. right? So for as a law student, when I was in my law schools, of course, when everyone whomsoever is a law student here knows that in law colleges it's morely a very theoretical subject, theoretical knowledge which we get. Eventually, when you become a lawyer, then only you are exposed to such contract drafting, such serious drafting. But in law schools also, in my personal view, there can be various avenues which you can try to improve your drafting skills. The first and foremost thing which is very important is that you have to read as much as possible. And reading is not just limited to law books, right? Read literature, read a good judgment, right? There are there are few judges who will write excellent judgments, right? So do a thorough analysis, do a thorough study of those judgments. So that is number one. Number two is, you can today on the internet you have various different forms of agreement, various different forms of contract. You just do a Google search, you will have different templates of contracts, be it a lease deed, be it an MOU, be it a family settlement, right? Be it any other form of agreement, click wrap agreement or standard loan agreement. So as I said, every agreement is a different story. Every agreement is different, right? So pick up one of the agreements and make it as a habit, right? Just go through the clauses of that agreement very carefully. Just see as to what are the clauses which has been inserted in that agreement and what is the purpose behind it. Like say for example, if I'm telling you that in a contract the termination clause becomes very important. So there is a purpose behind this. There is a reason behind inserting that clause in an agreement. The reason behind that is that, like say for example, if in any agreement there is no termination clause, right? And you know things can go worse in any contract, in any situation, at any time. So what will the party do? If suppose if someone has to terminate the clause, terminate the contract, and there is no termination clause, then the only option is to go to the courts. You have no option. You have no nothing left in the contract, right? Then you are at the mercy of the courts. Then you are at the mercy of the other side, whether the other side will accede to your request or not for termination, right? So every clause has a specific purpose. The insertion of every clause in different form of contracts will have its own purpose, right? So, so what I'm trying to tell you is this: that pick up any contract, read it, and understand as to the importance of those clauses in a contract, right? And the more you do this exercise, right, the better you will become in understanding the nuances of a contract, right? And make it as an habit. Don't read it like, I have read one contract and that's it, I become an expert in a contract. No, the more you read it, the better you will become, right? You can have MOUs, you can pick any agreement, loan agreement, debenture agreement. There are various kinds of contract. You have bank guarantees, right? So, so there are various contract. There are various contracts on which the dispute often comes before the court. One is a lease deed. Second is a bank guarantee, right? Now, a bank guarantee can be of various forms: irrevocable bank guarantee, revocable bank guarantee, right? So, what are the clauses? So, what is the distinction in these kind of contracts, right? A lot of people would have studied banking laws by now. People who have not studied banking laws, for them, this distinction becomes very important. Now, this will help you in real life. I think the audio is not very clear, or what?
No, sir, it's clear.
Perfect, perfect. Yeah. So just to continue from where I left, so go through a contract whenever you get time. Fix a schedule. Like say for example, in 1 week, I will go through one different contract. Then again, in next week, I'll go through one contract. So the more you do this exercise, the more you are continuously doing this exercise, you will become future ready, right? And now at this juncture, when you're in till the time you're in law school, the pressure on you is not too much, right? You have a lot of time, The moment you come out of law school and you are part of any law firm, or you start practicing, or you have, join a company or a bank, there will be tremendous pressure on you, and they will expect that at least you have read these things, you have gone through these things, right? So in order to become job ready, in order to become future ready, these are key points which I can tell you from my experience, right? There are, of course, I was in my law school, I also did not do a lot of things which I realized later that I could have done this exercise. But now looking back, I think if I could have done these things which I'm telling you right now, right? So these things would have been very much beneficial when I landed up and started doing my work.
Screenshots.
So, as an
नहीं हो रहा
and
नहीं हो रहा
another very good example is that you go to any website,
ये तो उससे वो हो
they
गया.
will have a click wrap agreement, standard agreement. You can go through that. You can understand. Of course, now another good example which I'll tell you. So, any click wrap agreement will have provisions of IT Act also, Information Technology Act. Data. Now we also have a data protection bill, a data protection law in India, right? So now every agreement will get revised. So you can now make a distinction between an old draft and a new draft. So this will happen when you will analyze the old draft. This will happen when you will analyze the new draft, right? So that distinction, that final distinction, if you are able to draw when you are still at law school, will really help you. Plus, what my one of my seniors used to say, that a beauty of a good draft is in the details, right? So there are two theories on this. There is the first theory says that use the standard clauses, let's prepare a draft and then finalize it. The second theory is that let's go into the detail, right? So, I mean, on a lighter note, when a lawyer is paid for drafting, right, and the payment is very good, then you go into the detail. Otherwise, for lawyers also, it's a standard thing. They know that these are the boilerplate clauses, these are the standard clauses which I need to include. There is very less scope for negotiation. You draft accordingly. But when you are given a task, when you have to specifically create or mold a contract according to the demand of both the parties, first party, second party, and there can be multiple parties, right? Then you use your creative skills. See, as lawyers, you have a lot of opportunities to be creative, but that creativeness has to be within the four corners of the scope of agreement only, right? But still, when you draft a contract, when you draft clauses of a contract, right, then you can use your creative skills, right, to modify the clause, to amend the clause, and then that agreement will be subject to further negotiation, further discussion. There can be modification by both the sides, right? And then you arrive at a final contract, right? So now the next point which I would like to address is that as lawyers, as law students, you should always keep your eyes and ears open, right? You should be aware of what's happening around you, right? Now, the significance of this is that suppose you have to draft a contract, as I said, I will give example of the new data privacy law itself. Now, if someone is drafting a contract which has elements of IT laws, data laws, and if someone is not aware that the data law has been passed, there's a new law, right? This also applies to various new laws, right? So one should be aware of what is happening around. What are the new legislations which are coming? What is latest in terms of law, right? Another example which I can give here is the recent judgment by the Supreme Court with regard to arbitration. Now, Supreme Court has said that any unstamped agreement cannot be relied upon by the parties. So, if suppose you're not aware of this fact, you're not aware of this judgment, and you draft an arbitration clause, or maybe you are invoking the arbitration, you don't know that new judgment has been passed, then if then it does not reflect very good on you because you're not aware of the latest position of law, right? So the purpose what I the point which I'm trying to make is this, that you have to be aware of what is happening around. So that is the reason why you keep your eyes and ears open as to what is the latest position in law. And so this is in terms of the terms and conditions of the contract. This is in terms of the key ingredients of the contract. Now, another important aspect which I would like to touch upon is the essentials of Indian Contract Act. Because you see, what is the basis of any contract? The basis of any contract is the Contract Act 1872, what we have, right? Now, if someone can just pick up the Contract Act and start going through, right? So there are various chapters in the Indian Contract Act. I'm not sure how many of you have studied the Contract Act as of now, but then there are various chapters under the Contract Act, right? The first chapter will talk about communication, acceptance, revocation. Then you have void contract, voidable contract. You have contingent contract, you know, and then you will have indemnity guarantees, consequences of breach, right? So more or less, the aspect of Indian Contract Act, the aspect which has been covered under the Indian Contract Act, is sufficient for a law student to know, right? So if someone is drafting a contract, like say for example, if someone has been given a task to draft a lease deed, so if you see the Indian Contract Act, there are certain provisions which specifically talks about the aspect of the rights and liabilities of lessor and lessees. You can also refer to other legislations, Transfer of Property Act, for that matter, right? Because it specifically talks about the rights of lessor, rights of lessees. Now, in this context, let me now uh, project my PowerPoint presentation where I will just quickly touch upon the ingredients of any contract, or what is a valid contract, what is not a valid contract, what are the essentials of a good contract. So I'll just project my PowerPoint presentation. Give me a minute, please. प्रेजेंटेशन प्रेजेंट कर रहा है उसको पिन करें अभी. So is my screen visible?
Yes, sir, it's visible.
Okay, perfect. Yeah. So, as I said, what is a draft? What is drafting? Drafting, as I've already said, is a synthesis of law and facts in a language in legal sense, means an act of preparing the legal documents like agreements, contracts, etc. So, a proper understanding of drafting cannot be realized unless the nexus between the law, the facts, and the language.
Sorry, sir, to interrupt. The screen is showing the members.
No problem, no problem. So, what I'll do, let me just give my presentation like this only, right? So, if you see Indian Contract Act, I'll just touch upon the few important provisions from the Indian Contract Act, which talks about what is a contract. So, if you see Section 2H of the Indian Contract Act, so any contract enforceable by law is a contract. This is what Section 2H of the Indian Contract Act says. Now, what are the essentials of a contract? Section 10 of the Contract Act says that these are the essential elements of any contract. There has to be an offer, acceptance. There has to be a consensus ad idem. There has to be consent between the parties. The capacity of the parties should be there. So I will touch upon all these aspects later also. The consideration should be lawful. The object for which the contract is being executed should also be lawful. There has to be a certainty of meaning and possibility of performance. And the contract should not be expressly declared void. Now, as you know, what is an offer and what is an acceptance in any contract, right? These are all the terms which have been defined under the Indian Contract Act. One can go through the contract. It's a very easy read. It's not a difficult legislation. But yes, for the purpose of this presentation, a offer or a proposal is when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of the other side. So section 2b of the contract says, when the person to whom the proposal is made signifies his assent, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Now, consensus ad idem. This is a very important aspect as far as the contract is concerned. So, the word consensus ad idem, which is mentioned, means the meeting of minds. It implies that the parties to a contract should agree on the same and exact meaning and purpose of the contract. Like, say, for example, if suppose if someone is saying that I offer you this house for so and so consideration. Now, the word this house, until unless it is very much clearly defined or meant in the same manner by both the parties, there is no consensus ad idem. There is no meeting of mind, right? So the word consensus ad items become very important when it comes to the formation of a contract. Now the next aspect is the aspect of consent. So if you see section 10, it says a consent is only valid if it is by a by it has to be freely accepted by both the parties, and that consent has not been obtained by coercion, undue influence, fraud, misrepresentation, and mistake. So now, if you see the Indian Contract Act, of course, when you talk about fraud, misrepresentation, undue influence, in first instance, if you see, these are all, these are also captured under the Indian Penal Code, right? But there is an element of civil, there is also an element of civil criminality. There is a fraud, misrepresentation, undue influence. So if any of these things are there, right, it does not amount to a free consent. Now, what is the consequence of this? Like, say, for example, if someone has obtained my consent out of misrepresentation, so in that case, the contract becomes voidable. Now, as you know, there are two concepts. One is a void contract, one is voidable contract. Void contract is something which is from the very beginning, it is void. Like, say, for example, if you have contracted against a provision of law, then it's a void contract. But if there are certain contracts which is not expressly void in eyes of law, but if one of the parties elect to make the contract void or voidable, that's a voidable contract. You have that option to adopt maybe at a later stage when you get to know that there is a fraud which has been played upon, there is a misrepresentation which has been played upon, right? Then there is an option to the other party to declare the contract as voidable contract, right? So that is in terms of the aspect of consent. Then capacity of parties. Capacity of parties means that if the contract is being executed, the contract has to be by a sound person, firstly. Secondly, the parties who are entering the contract has to be a major. There can be no contract unless the minor is being represented by his guardian or an authorized representative, right? Suppose if, and also there is a third category wherein the person who is entering the contract is not properly authorized by the company itself. So, like in present in our matters, in the matters which we deal with, if there is an authorized representative by the company who has come forward and who is executing a contract on behalf of the company. So, if there is no board resolution which is specifically authorizing that person to execute that contract, then tomorrow, if a challenge is raised regarding the execution or validity of the contract, right? So that authorized representative himself is not authorized by any authority letter, board resolution, or a power of attorney. Then in that case, the contract becomes voidable. So capacity of parties becomes very important when it comes to execution of a valid contract. Then there has to be a lawful consideration. Now, what is what does section 2d of the contract act says? So it says, when at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do or abstain from doing something, such act or abstinence is called consideration of the for the promisee. So I know the definition here of consideration is not as simple as it should have been, but that is how the legislature has intended to draft. But in simple words, what is a consideration? Like say, for example, in a lease deed, what is the consideration? Money. In a family settlement, what is the consideration? The consideration is the vesting of property amongst few family members, right? So this can be understood in such layman language. Then consideration should be lawful. Now, if you see section 23 is an important provision. If you want to make a note of this, so it says the consider what it reads is what consideration and objects are lawful and what not. So it says the consideration or object of any agreement is lawful unless it is forbidden by law. So if the consideration is forbidden by law, that consideration is not lawful or is of such nature that if permitted it would defeat the provisions of any law. So as I said, if your consideration in itself is against the law, then it's not a valid consideration. Involves or implies injury to person or property of another, that consideration is also not lawful. Similarly, there are other examples as well, which are there under section 23. So whenever you get time, you can have a look on at section 23, and you can know as to what considerations are lawful. Then of course there has to be a lawful object. As I said, it should not be forbidden by law, or it should not be of such nature that if permitted it would defeat the provisions of law. Now see, the certainty of meaning and performance and possibility of performance also becomes important. So the terms of agreement must be clear and unambiguous. Agreements, the meaning of which is not certain or capable of being made certain, are void. Now, there is a provision under Contract Act, which is Section 29, which very clearly says agreements void for uncertainty. Like, I'll give you an example. Of course, there are certain illustrations under the Indian Act also, which which is an easy read, which clearly says that what contracts are uncertain. Like say for example, if A agrees to sell B 100 tons of oil, right? It says there is nothing whatever to show what kind of oil was intended. Any generic contract that says I will give you 1,000 rupees, when will you give, in what manner the agreement, the money will be given. So that is the reason why I have emphasized at the very beginning that one has to be very clear. See, and a good agreement does not require it to be superfluous. A good agreement does not require it to be elaborate. It can be as simple as that. Like only in this example, in illustration, if the illustration was like this: A agrees to sell B 100 tons of mustard oil to be delivered at this and this location. Now, there is a certainty attached to this clause. There is a certainty attached to this kind of agreements. So, this agreement will never become void or voidable because it's certain, right? So, any uncertain contracts are void. You can also refer to Section 29 of Indian Contract Act. Now, the next aspect is the aspect of, as I already said, some principles of effective drafting. There should be a brevity, it should be brief as possible, there has to be clarity, and it should be simple, right? Now this more or less will cover the aspects of a drafting of a good contract. Now one more aspect which I would like to touch upon, and as future lawyers, one should be aware of these things as well, that contract drafting is one aspect. The another aspect is the drafting of a pleading for pleading for any court, right? Now you pick up any book, and I'll give you three books which you should jot down, which talks about or which deals with what a good pleading should contain. First and foremost guide is your code of civil procedure. Now, if you pick up Code of Civil Procedure, that's a complete guide in itself, as you all know, right? Now, if you see Order 7, Rule 1 of the Code of Civil Procedure, It defines what a plaint is, right? And as you are aware that in any civil litigation, there are two very important aspects. One is plaint, the other one is your written statement. Now, if you see Order 7 Rule 1, it says the plaint shall contain the following particulars: the name of the court, description and residence of the description and place of residence of the plaintiff, facts showing that court has jurisdiction, the relief which the plaintiff claims, description of the dispute in the matter, right? So this is covered under Order 7 Rule 1. So this is a kind of a Bible for anyone who has to draft a petition. Similarly, when it comes to your written statement, now written statement essentially is the rebuttal to the plaint, right? So what should a written statement contain? Now the law says, now if you see Order 8, it specifically talks about written statement and counterclaim. So it says that every averment in the plaint has to be specifically rebutted. So you have to be specific. Otherwise, a smart lawyer will use your own written statement and say that he has not denied this. So hence it is admitted. And there are, of course, judgments from various courts as well. Similarly, you have, when it comes to Supreme Court, when you have high courts, right? So if someone intends to practice before Delhi High Court comes or intends to come to Delhi, then your Delhi High Court original side rules will act as a guide. So in that also, there is a chapter, which is chapter number 3, which says what is the form of a pleading. That means what should be contained in your pleading or plaint or a suit which you file before the court. Similar example, if someone intends to go to Supreme Court, then you have Supreme Court Rules 2013. Now, that Supreme Court rule also contains what should be the exact particulars of a plaint. So it says every suit shall be instituted by presentation of a plaint. A plaint should be presented to the registrar. Now, a plaint shall contain the following particulars. Now, please note, this is very important: the name of the plaintiff and defendant, the facts constituting the cause of action and when it arose, the facts showing that court has jurisdiction, the declaration or relief which the plaintiff claims, right? It also says a plaint shall be rejected where it does not disclose a cause of action, where the suit appears from the statement of plaint to be barred by any law. So these are all something which once you enter into profession, you will realize and keep start doing it. Similarly, when a lot of you might also be actively participating in moot court competition. Now I also act as a judge, as moot court judge in a lot of competitions. So what I have seen in my experience is that a lot of times the participants are not aware of the facts, right? Now when we file any petition, when we do deal with any matter, the most important thing, and this also applies to a contract drafting, the most important thing is your list of dates as to what transpired on this date from A to Z, from the very beginning till the end. So when you have a list of date for any matter, right, and you must try this in terms of any judgment also. Whenever you read any judgment, just make a note on the side of the judgment itself as to the relevant dates, right? Now this, the usefulness of these dates, list of dates, comes into picture when you start drafting any contract also. Like if you have to give a recital for any contract, if you have to describe that the reason why the parties are entering into this contract is because of xyz reasons, xyz things. Now what are those things? If you corroborate those events with a date, then your agreement will become foolproof. You have covered most of the points, 95% of the contract, of the points you have covered in your draft, right? So So the usefulness of list of dates will becomes very handy when you draft any contract, when you draft any pleading, when you draft any moot court memorial, right? And it's always good to keep list of dates in the back of your mind whenever you approach any sort of drafting. Now, one more important aspect is, which I would like to touch upon is the usefulness of a good email. Now, the more you read, the more you prepare yourself for becoming future ready, right? The better you become. So the more you read, it will also get reflected in the way in which you communicate to recruiters, to maybe your own peers, right? So I think I've spoken a lot now on all the aspects of essentials of drafting, and now it was a monologue. So let me now open the forum for dialogues. If you have any query, you can ask, and then let me try and address that. Sakshi and Paras, over to you now.
Thank you so much.
Sakshi.
Thank you so much, sir, for joining the webinar. And I would like to call our founder, ma'am, for the vote of thanks.
I think prior to that, if the participants have any queries
Yes,
with
sir,
regard
we'll
to
be taking queries now. So if anyone has any query, please do write it in the chat box. And I so someone is asking any good reference book for drafting. It's appeared.
So by offhand, I don't remember, but I have seen there are few good drafting books, and you can have from any good publisher. So most of the drafting books which you will take will essentially. So there are two categories of drafting books. One category of drafting book will have the template standard formats, like these are the standard formats which are used for drafting. The second category of book will tell you that what are the key essentials of a good draft. So that will not be a very thick book, because as you say, this is a very open subject, right? So you can pick up any good book. The point which I'm trying to put forth is that the more and more you read any good draft, any good contract, the better you will become, right? So as of now, I don't do not recollect any good drafting book, but I will suggest something. Let me look into my library, and then I will suggest a good read as far as the drafting is concerned. So Bhumika has asked a question: is negotiation is important skills to have in drafting? One second. Is negotiation an important skill to have in drafting contract or dealing contracts? Yes, a very important skill. So as I said, the aspect, there are various contracts which the negotiation of such contract goes on and on, because the amount or the consideration involved is so much that without the negotiation on various clauses. Now when I talk about negotiation, you won't believe the kind of negotiation happens on one clause. There are like tons and tons of clauses in a contract, right? So yes, the answer is yes. A good negotiation skill is very much required for a good draftsman, but these are all matters of experience. As I said, the more you do it, the more you deal with it, right, the better we will become. Now I understand that there are various competitions also, wherein it's specifically targeted for negotiation skills, for improving your negotiation skills. So that can be one of a good resort to apply to, if you intend to improve your negotiation skills. Yeah.
Sir, what is recital?
Yes. So Aditya, if you read any, can you mute Aditya? I think there's some disturbance on your side. Yeah. So a recital essentially is a prelude to the main contract, is a background to the main contract. Like So recital will contain some component of the contract, but it does not contain the terms and conditions. I hope it addresses your query. Sakshi
Does
Paras.
anyone have? Yes, sir. I was just asking if any other student has any other query, please to write it in the chat box so that we can, convey the same to sir.
बच्चा आप क्वेश्चन चल रहे हैं शायद
Sir, I don't believe there are any other queries as
No
of
problem.
now. Yes, sir. So, just as Paris said, I wanted to give a vote of thanks. So, sir, I really appreciate you joining this session and taking out your precious time for us and all the students who are present here. It was a great honor having you. And surely, not just the students, even we all learned something great today. Okay, there's one question, sir. Uh,
Physics.
I believe it is, sir, the scope of legal drafting in legal field right now. Sneha Chauhan is asking this
Yeah, so
question.
Sneha, legal drafting is something which we all do on daily basis. So you understand, every draft which we prepare. So what is legal drafting? Anything which has legal elements is a legal draft, right? So the scope is very much open, but yes, not everyone becomes a good draftsman, right? So the key to become a good draftsman is to understand why we are preparing that contract.
Article.
What are the main elements of the contract, right? So these are some key ingredients. As I said, there is no shortcut for this. The more you do it, the better you will
लेकिन
become.
तो थर्ड दिन घर से उसका
This also goes for anyone
ये नर्सिंग
who
डे
intends to
प्रॉफिट बने
tomorrow go for litigation or join a litigation chamber.
आपकी में टीम थोड़ी होती है
Eventually, every lawyer who is a sincere lawyer, who is a dedicated lawyer, will become better at it. But the only thing which is required is you have to put in efforts. There is no substitute for that. I hope, Sneha, I am clear.
Definitely, sir. And as all the students are already saying, it was a great session, sir, and we all learned something really important today. And you've thoroughly explained the topic to all of us. So thank you so much for joining the session, sir. We look forward to interacting with you more. It was an honor having you here with us today.
You are most welcome, Sakshi, and I hope that whatever I have said today from my own experience will help you. And the pointers which I have told you in terms of studying more and more, reading more and more contracts thoroughly, and make it as an habit. You can't expect that I will read one contract in 1 month and I will become good at it. No, you have to do it again and again. You can pick up any draft. Today the thing is that everything is available online, right? You can have thousands and thousands of draft of a good contract, right? And of course, there is no substitute for a good judgment of any court. So yes, one more thing which I would like to point out, that there are certain good judgments of various from Delhi High Court and Supreme Court, which says that what should be included in a good draft, in a good pleading. So one can also go through those judgments and do some research and read it. So that will also help a lot. So I think
Definitely,
with
sir.
these
I
words,
believe everyone here will do that.
I will provide you the citation, Satyen. I don't have as of now, but I will share that with Sakshi, and then Sakshi can maybe Sakshi can pass on the citation of the Delhi High Court judgment. All right,
Sure, sir. I'll do that.
perfect.
And thank you once again, sir. It was great
My
having you
pleasure.
with us
My
today.
pleasure. All the best, everyone.
Thank you so much, sir.
Thank you so much, everyone, all the participants, for joining the today's webinar. And the certificate will be provided by tomorrow. Now you can leave the meeting.